Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Good afternoon, everyone. My name is Rasa Fumagalli. I am an attorney licensed in Illinois, and I am the Director of Medicare Secondary Payer Compliance here at Synergy Settlement Services. I would like to welcome you to our third Thursday of the month webinar. Today, we will be looking at issues with Medicare Secondary Payer Compliance settlement terms and talking about some ways to avoid them. Synergy Settlement Services provides a wide variety of services that can help you, the attorney, when it comes to resolving various issues with your claim after settlement. We offer Medicare Secondary Payer Compliance, government benefit preservation, settlement planning, assistance with group projects, attorney fee deferral, as well as healthcare lien resolution. Now, some of the things that you may have come across after you reach a verbal settlement agreement might include the defense providing you with 2 pages of MSP compliance terms. And the compliance terms are likely something that was never discussed in connection with your settlement. We've seen situations where the defense puts in an obligation that the plaintiff secure a written certification from the treating physician that no further care is needed that is injury related. That in and of itself would not be problematic if that was something that was actually discussed in connection with the claim. We've also seen situations where the defense is going to unilaterally put in a requirement that the plaintiff fund a Medicare set aside. We have seen language where the defense wants the plaintiff to agree to never bill Medicare. So clearly, these provisions are not provisions that are appropriate for many of the cases that are being settled. Other issues that we've seen in regard to Medicare Secondary Payer Compliance terms are when the terms simply cannot be met. If the provisions require the plaintiff to submit a liability Medicare set aside to CMS for review, that is really not an option most of the time, and it shouldn't be in there. We've also seen very inconsistent MSP compliance settlement terms where in one part of the paragraph, everybody is agreeing that the plaintiff is not on Medicare. Yet a few sentences down, there's an obligation to reimburse Medicare for conditional payments. If you are not on Medicare, there aren't any conditional payments. One of the more egregious terms that I recently came across involves a statement where the releasing party is expected to understand that acceptance of settlement funds may affect her rights to other benefits, including but not limited to the suspension or revocation of Medicare benefits at Medicare's sole discretion. So this provision as written really is inconsistent with any potential exposure under the Medicare Secondary Payer Act. Because the plaintiff is a Medicare beneficiary in this case, and she's receiving a great deal of treatment for non-injury related, you know, conditions, this was extremely frightening for her, and it essentially blew the settlement. We have seen some litigation to enforce settlement terms that include provisions that were never agreed upon. In Kapalati versus Village of Timber Creek Association, we have the Superior Court of New Jersey in January of 2021 deciding that the plaintiff was entitled to have a motion to enforce her settlement agreement granted. And this dispute arose from the defense adding terms that required the plaintiff's treating physician to certify that she would not require any additional treatment or monitoring. And this request was never discussed during the settlement negotiations. The defense argued that the inclusion of this requirement regarding future treatment was standard practice. The court did not buy it. They found that it was inconsistent with industry customs, and the plaintiff was allowed to enforce the settlement agreement. So, how do you actually prevent these problems from cropping up after you finally reached a tentative settlement agreement? One of the ways to make sure that you can avoid this is to actually have a good understanding of what the MSP compliance obligations are in a case. And if this is something that is not within your area of expertise, it would be prudent to consult with an outside expert. So the next step after you know what the Medicare Secondary Payer obligations are is to have a discussion with your client about how the Medicare Secondary Payer Act may actually impact their settlement once the settlement papers are approved by the court. Once you have this decision of how to proceed in terms of MSP compliance, you should, of course, document the decision and act upon it. So let's take a look at what the Medicare Secondary Payer obligations are in a case. So Medicare is a payer of last resort or a secondary payer when payment has been made or can reasonably be expected to be made under a workers' comp law or plan of the U.S. or a state or under an automobile or liability insurance policy or plan. And this includes a self-insured plan or under no-fault insurance. So any Medicare secondary payer compliance obligation is going to circle back to this provision. And because Medicare is a secondary payer, Section 411.2 of 42 CFR states that Medicare is precluded from making payment for services to the extent that payment has been made or can reasonably be expected to be made under workers' comp, liability, or no-fault insurance plan. Now, even though Medicare is a payer of last resort or a secondary payer, they don't want the Medicare beneficiary to go without treatment after they have an injury. So there is an exception to Medicare being prohibited from making payment. Medicare is able to make a payment when payment is not reasonably expected to be made promptly, and that's defined as 120 days of receipt of the claim by the primary payer. So if Medicare makes a payment before a case settles and the payment involves injury-related treatment, Medicare is entitled to be reimbursed for that conditional payment. This reimbursement obligation kicks in when there's a judgment against the defendant. There is a payment conditioned upon the recipient's compromise, waiver, or release of payment for items included in a claim against the primary payer or by other means. It's important to note that in this particular provision, it also states that that reimbursement obligation is demonstrated whether or not there is a determination or admission of liability. Another thing to be aware of is that this reimbursement obligation is also demonstrated whenever there are conditions that are released in the settlement. So it is way better to actually have a very focused approach to what conditions are actually being settled in the case as opposed to throwing everything in, because these various diagnosis codes are going to be reported to Medicare, and Medicare may view all these other conditions as conditions for which they are a secondary payer. So there are essentially three different components to Medicare secondary payer compliance and what your obligations are. So the first obligation involves the need to address Medicare's payments for pre-settlement injury-related treatment, which are conditional payments. Medicare is going to know that there has been an accident in a settlement because of the mandatory insurer reporting obligation under Section 111. Since Medicare is prohibited from making payment when payment has been made, which is what the settlement is actually considered in the eyes of Medicare, you have to consider whether there's going to be any post-settlement injury-related treatment. And that is a consideration of Medicare's interest in the future medical in the claim. The Section 111 reporting obligation, which falls on the defendant in the case and their responsible reporting entity, requires a Medicare report of the total payment obligation to claimant when there is a liability settlement involving a current Medicare beneficiary. As you can see, the dollar amount of the settlement has steadily decreased over the years. In 2011, the liability carrier only had to report settlements that exceeded $100,000. In January of 2017 to the present, the liability carrier has to report any settlement involving a physical trauma that exceeds $750. All other settlements involving a current Medicare beneficiary have to be reported regardless of the settlement amount. In light of the Section 111 mandatory insurer reporting obligation, Medicare is going to have notice of a settlement, which means that Medicare is going to be looking for reimbursement of conditional payments that were made. One of the things that you have to consider when we're talking about Medicare secondary payer obligations is to be mindful of the fact that conditional payment information oftentimes is interim conditional payment information that may be updated and have a different figure after the case fully settles. There are also different types of Medicare coverage. So when you have a client who is a current Medicare beneficiary, you should identify the type of Medicare coverage they're enrolled in. So Medicare Part A is hospital coverage, and it covers inpatient hospital stays, care in a skilled nursing facility, hospice care, and some home health care. Traditional Medicare Part B insurance will cover certain doctor services, outpatient care, preventive services, and medical supplies or durable medical equipment. So if your client is enrolled in traditional Medicare Part A and Part B, you are going to be able to request the conditional payment information from Medicare because they will have this information in their database, which they can share with you. Your client may also be enrolled in a Medicare Advantage plan at some point during the life of their claim if they choose to switch from traditional Medicare Part A and Part B. So Medicare Advantage plan is administered by a private insurance company, but it's paid a fixed amount each month by Medicare. So for example, Humana has a Medicare Advantage plan. United Health has Medicare Advantage plans as well as Blue Cross Blue Shield and so forth. So the Medicare Part C and Part D plans, they include all of the Part A and Part B coverage plus more. So the Part D plans are drug plans that are Medicare covered. You should also be aware that the Medicare Advantage plans use the Medicare Secondary Payer Act as their recovery vehicle. If you are looking to find out what a Medicare Advantage plan paid, you would have to go seek this information from the plan itself. Medicare does not share the Part D information and the Part C information through the Benefits Coordination and Recovery Center or the entity that you would reach out to when there's a traditional Medicare Part A or Part B plan. The reason everybody is concerned about reimbursing Medicare is that there are some significant penalties that can come into play when Medicare is not paid. 42 CFR 411.24 talks about the fact that CMS has a right of action to recover its payments from a primary payer, a beneficiary, provider, supplier, physician, attorney, state agency, and a private insurer that has received a primary payment. The reason that a lot of defendants and insurance carriers do put in this overly broad, inappropriate Medicare Secondary Payer compliance templates is because they are concerned about this ability of Medicare to actually seek recovery for conditional payments from the primary payer. When a primary plan fails to address conditional payments, or the plaintiff fails to address conditional payments, the Medicare Secondary Payer Act provides for a private cause of action for double damages. And this is found in Section 1395 YB3A, which basically states that there is a private cause of action for damages, which shall be in an amount double the amount otherwise provided when a primary plan fails to provide for primary payment or appropriate reimbursement. There's no doubt that Medicare takes their reimbursement seriously. So let's take a look at one of the older cases where a claimant's attorney was pursued. And this is a 2009 claim called United States versus Harris. Now, Harris was representing a plaintiff who was a Medicare beneficiary. He entered into a settlement agreement with the defense for $25,000. Medicare had made conditional payments that were in the area of $22,500. After Medicare was notified of the settlement and you had the reduction for procurement costs, Medicare issued a final demand seeking $10,253. For whatever reason, the attorney did not pay and his client did not pay. So Medicare sues the attorney in federal court as a third party who received payment from a primary payer or the defendant. And the attorney filed a motion to dismiss, stating that the only thing he had to do was let Medicare know that there was a settlement. And, the court disagreed and they held that a primary plan, whether it's the insurance company, the attorney, or the other parties that we previously enumerated, can be held liable. So it's unclear why the attorney thought that all he had to do was advise Medicare about the settlement, especially when they had a conditional payment demand, which always clearly sets out what the obligation is. So the attorney in a case should really pay attention to make sure that the conditional payments that are being claimed in connection with the settlement are resolved. So we've had a continuation, though, of law firms that choose to ignore conditional payment demands. And if you fast forward here, you can see that the Department of Justice is actively engaged in pursuing plaintiff firms for unpaid Medicare debts. Let's take a look at a situation where there was a medical malpractice claim and the law firm's client received a $1 million settlement in 2015. Medicare is given notice of the settlement and they asserted a conditional payment recovery claim. The firm did not reimburse Medicare even when the debt became final by way of a final demand. And nothing happens then for several years until we fast forward to March of 2019. At that point, there was an announcement by the U.S. Attorney for Maryland that Maryland's personal injury law firm had agreed to pay the U.S. $250,000 to settle claims that it did not reimburse Medicare for conditional payments that had been made on behalf of the firm's client. In connection with this settlement agreement, the law firm also had to designate a person at the firm that is solely responsible for paying the Medicare secondary payer debts. That person has to be a trained designated employee, and there was an obligation to review any outstanding debts with a designated employee at least every 6 months to ensure compliance. Here's a quote from the U.S. attorney in the case. He wrote, "The settlement reminds attorneys of their obligation to reimburse Medicare for conditional payments after receiving settlement or judgment proceeds for their clients. The settlement should also remind attorneys not to disburse settlement proceeds until receipt of a final demand from Medicare to pay the outstanding debt. We intend to hold attorneys accountable for failing to make good on their obligations to repay Medicare for its conditional payments." In addition to the Maryland case, you can see that the Department of Justice has also entered into settlement agreements that we know of with at least 3 other firms in November of 2019, January of 2020, and the most recent one is August of 2020. As I mentioned earlier, at this time, about 39% of all Medicare beneficiaries are enrolled in a Medicare Advantage plan. And because of this, it is really important to be mindful that the private cause of action has been extended to Medicare Advantage plans. 42 CFR for Section 422-108F specifically states that Medicare Advantage organizations will exercise the same rights to recover from a primary plan, entity, or individual as the Secretary exercises under the MSP regulations in subparts B through D of Part 411 of this chapter. This right of recovery by the Medicare Advantage organizations is also discussed in a memo from CMS from December of 2011. This memo indicated that Medicare Advantage plans have the same rights to recover as Medicare. We have seen since 2012 litigation in this regard. The very first case that found a Medicare Advantage plan could maintain a private cause of action to recover conditional payments made on behalf of a beneficiary was in Re Avandia, and that was a Third Circuit case. There was also a case in 2016 where Humana sued a plaintiff's attorney for failure to reimburse conditional payments. The court in the Fourth Circuit allowed the Medicare Advantage plan's suit to proceed in 2016. There is also the case of Humana Medical Plan versus Western Heritage, which was decided by the 11th Circuit in 2016. This case indicated that Humana was entitled to double their lien amount against Western Heritage. The case also addresses a situation where Western Heritage had actually reimbursed the beneficiary for the payments that Humana was seeking, and it was on the beneficiary's shoulders to actually reimburse Humana. So the Humana Medical Plan versus Western Heritage case indicated that a primary payer has to reimburse Medicare even though they've already reimbursed the Medicare beneficiary or other party. And that specific provision is outlined in 42 CFR section 411.24. So as a practitioner, it's important to understand the difference between a final conditional payment demand, which is a fixed amount, as opposed to an interim conditional payment number, which may change. It's also important that you realize that you cannot get information on Medicare Advantage plan payments in the same way as you can secure traditional Medicare Part A and Part B payments from the Benefits Coordination and Recovery Center. So the Medicare beneficiary's report of a claim to the BCRC will result in the BCRC providing conditional payment information under Medicare Part A or Part B. If you want to obtain information regarding the Medicare Part C and Part D payments, you're going to have to go to the plans themselves. And another thing that you should consider and you should be mindful of is the fact that there are 2 different types of reporting going on when it comes to liability cases and workers' comp cases. So A Medicare beneficiary has an obligation to report an accident to Medicare, and this obligation is part of their process when they enroll in Medicare. And that is a very different type of report than the report that is done by the responsible reporting entity for a primary plan under Section 111. Section 111 reporting is a mandatory insurer reporting obligation that is placed on the defendant and the RRE for the primary plan. When a case involving a current Medicare beneficiary settles and it's a liability case involving a physical trauma and the settlement exceeds $750, the primary plan's RRE is going to make their Section 111 total payment obligation to claimant TPOC report. Another thing you have to be aware of is that when you have a case that has actually been in your office for an extended period of time, it's quite possible that you may have a situation where your client, the Medicare beneficiary, has enrolled in different plans over the life of the claim. He may start out enrolled in a traditional Medicare Part A and Part B plan. 3 years go by, he may switch over to a Medicare Advantage plan. After another year or so, they might switch back to traditional Medicare, or they may enroll in a completely different Advantage plan. So it's important to stay on top of the different types of coverage that the Medicare beneficiary may have over the life of the claim. There's some things you can do to help make the conditional payment process go more smoothly in a claim. I would recommend that you request copies of your client Medicare beneficiaries' health insurance cards once you sign them up. It's also a good idea to request updated information during the life of the claim. The medical records should be reviewed to see who is being billed at various times over the years of treatment. You should also be able to see the billing statements in the pharmacy records. It's a good idea to begin this investigation early. If your client does not remember the various plans that they've been enrolled in when it comes to Medicare, I would suggest that they open up and they register an online account on mymedicare.gov. It's a pretty good website that will show the different plans that your client was enrolled in once they became eligible for Medicare. Now that we've taken a look at the conditional payment obligations, let's turn to post-settlement injury-related care. Now, one of the things that you should consider when evaluating the Medicare Secondary Payer obligations in connection with future care is whether or not your client is currently on Medicare. If they are currently on Medicare, this is something that definitely should be addressed. If they are not going to be on Medicare for 10 years because they're young, then you might actually take a different approach to Medicare Secondary Payer compliance in that case. It's going to be a risk-benefit analysis. Once you've identified whether your client is on Medicare, you should next turn to whether your client is likely to need future injury-related Medicare covered treatment. If so, the consideration is then going to turn to, well, is the settlement actually sufficient to fund future medicals? When you look at what the objective economic damages are, when you look at what the policy limits are, and when you look at some of the other factors in the case. If it is a situation where the settlement will fund future medicals and future medicals were contemplated in negotiating the settlement, you should then turn to an analysis of whether there's actually any injury-related care that is covered by Medicare and if it is going to be shifted to Medicare once the case settles. If it is a situation where that is likely to occur, you want to avoid that since that is an improper shift, and you should consider the merits of securing a Medicare set-aside allocation. You can either fully allocate for future treatment or you can have an equitable apportionment from the settlement so that you have support for the figure that is carved out from the net settlement. Another thing to consider is whether your client has actually completed all of their injury-related care at time of settlement and whether or not their treating physician would be willing to complete a written certification that no further injury-related care will be needed. So these are all the factors that you should take into account when you're deciding what the appropriate course of action is in terms of future medicals. If you have this discussion and you think about this before you reach your tentative settlement agreement, you will be able to have a meaningful discussion about what should be in the settlement terms. Medicare secondary payer compliance is a specialized area. If you are not comfortable with addressing the impact of the Medicare Secondary Payer Act on your client's settlement with your client, you may want to consider a Medicare expert case evaluation. We do offer this at Synergy Settlement Services. There are 3 outcomes that are possible from this MECE consult. There's either going to be an analysis that no MSA is appropriate, or a recommendation that a Medicare set-aside analysis be completed. If your client, after participating in a consultation where the pros and cons and risks and benefits of various approaches are discussed, decides that they would prefer not to do anything, we would complete a Medicare set-aside acknowledgement and waiver for your client so that you have proper documentation in your file. So how do you avoid issues with poorly written, inappropriate MSP compliance settlement addendums? One of the ways to avoid this is to be proactive in understanding what the MSP compliance obligations are in the case and taking the appropriate steps to address them early on. It's also important to be mindful that the conditional payment figure, which you may have obtained from Medicare, may be an interim figure and is likely to change once the case fully settles. You can secure a final conditional payment demand prior to settlement in certain situations by initiating the final conditional payment process available to the beneficiary under the Medicare Secondary Payer Recovery Portal. There are specific timelines, though, that are involved, so that is something that may or may not be appropriate in your case. I would also recommend that prior to reaching a final settlement agreement with your opponent, that you consider what your client may require in terms of future injury-related Medicare covered treatments so that you can come up with an appropriate plan and be prepared for a discussion with the defendant about this component. Another thing that is a good idea to do is to coordinate the ICD-10 diagnosis codes that are going to be reported by the defense under Section 111 mandatory insurer reporting obligations. You want to make sure that correct diagnosis codes are reported by the defendant so that your client doesn't have any issues with erroneous ICD-10 codes being reflected in connection with the settlement. Thank you for your time this afternoon. And if you have any questions, I can be reached at rasaf@synergysettlement.com. I look forward and hope to work with you in the future.